Only take 15 minutes to do that. And I'll send the notes Monday.
No problem. I think I would grant you that particular latitude so that you can just go ahead and start the presentation. 15 minutes is actually ideal, so you may proceed.
Okay. So quickly, I'll just be a bit fast, but there are certain things maybe I'll try and as much as possible, maybe to try and simplify, because I realize even during our time there are certain things that may our lecturer try to omit certain terminologies. So I'll just go quickly because I'll only deal with maybe the definition part. And probably the preliminaries before one decides to enter into any merger or acquisition transaction. So there are certain terminologies, maybe can quickly go over them. I hope I'm audible so that I can maybe the students confirm. Okay. So there are terms that were probably defined by Alex, which certain students say were, I talked to him and he confirmed so. So the issue of mergers and acquisition, maybe I'll just brush in a layman's language. So when you talk about merger, and I'll refer you to leave alone the Competition Authority, the Competition Act, and go and read the regulations, the Capital Markets Takeover and Mergers Regulation, which gives a distinctive and quite clear definition of what a merger is. And this is what probably it said. A merger basically is an arrangement whereby the assets of two or more companies become vested in or under the control of one company. Basically, what this means is that, for instance, the merger that occurred between CBA and NIC, they became vested in under control of one company called NCBA. So it's basically A plus B is equal to C. However, when we come to what we call an acquisition, I know there's always a confusion, but I'll try it in layman's language. So when it comes to an acquisition, through illustration, you realize that, for instance, company X buys Y, right? And then Y becomes wholly owned by X. So what happens is that either Y can be, company Y can be totally absorbed and cease to exist as a separate entity. The other one is A plus B is equal to C. But here X plus Y becomes absorbed into X. And therefore you realize it ceased to exist as a separate entity. That's how I understood it during my study. So what happens is that company X, the company X can retain Y. There's an option. It's always limited. It can retain Y in its pre-acquired form. The reason as to why this is often practiced is where you realize that there is an intention of company X, to sell off Y at profit at some later date. So they just hold it like a broker. So you realize it just retains it in its pre-acquired form up to some point and then sell it off to another person at a profit at some later date. So that's how I understood the difference. Sometimes the act might confuse you at CBO, and then it includes, but in a layman's language, that is the difference. However, there are other terminologies that I think are very important. Others we can just list them. We have another one called takeover. When you talk about a takeover, basically this is a general offer to acquire all the voting rights in the offeree. So it's basically the offeror, issuing an offer to acquire all the voting rights in a company. And then we have what we call a reverse takeover. I hope we are together up to that point.
Yes.
Okay. So we also have what we call a reverse takeover. These are some of the things that maybe you should shine with during your CLE exams. What we call a reverse takeover is a situation where, let's assume, using the initial example I gave, CBA, who is the offeror. And then we have NIC, who is the offeree. So we realize that CBA, the Central Bank of Africa, makes a takeover offer to NIC. Remember, takeover is an offer of acquiring all the voting rights or all the voting shares. So you make an offer. For instance, the CBA makes a takeover offer for all the voting rights by means of exchange of shares. So they are exchanging, such that if that takeover is accepted, if NIC accepts such a takeover, the shareholders of NIC will control the offeror, who is the CBA. So it is just a reverse of the normal thing that we are trying to understand. And I'll repeat what I've said. A reverse takeover is where the offeror, let's assume CBA, makes a takeover offer for all the voting rights of NIC, who is the offeree. So by means of exchange of shares, they are exchanging shares such that if NIC accepts such a takeover, then the shareholders of NIC will control CBA. Hope umeelewa up to that point. Now, we also have another terminology, which I said earlier when I was, trying to define what an acquisition is. Is what we call ceasing to be distinct. Ceasing to be distinct. Now, when you find such a terminology, don't be confused in exam. Basically, it means brought under common ownership or brought under common control. That is what we call ceasing to be distinct. By this, and I'll repeat again, it means brought under a common ownership or control. So whether or not, we don't care whether or not the business formally, you realize that formally belonged, continued to be carried under the same or different ownership. So whether A or B, we don't care whether A or B were different kind of control. What we care is that it has come to C. What was earlier there has ceased to be distinct. Then we also call what we call a de jure control, de jure control. When you talk about a de jure control, I hope I'm not too fast. Okay. So when you talk about a de jure control, when you talk about somebody having a de jure control, it means basically acquiring shares that carries the right to exercise more than half of the votes at a general meeting. So long as you acquire shares that has the right or power to exercise more than half of the votes in any general meeting, then basically you have a de jure control. As opposed to what we call a de facto control, which is also a term in mergers and acquisition. A de facto control basically means that you have a right to control the policy of a body corporate without having a controlling interest in it. By this I mean, let's assume there is an investor in
Pardon?
I'm saying a de facto control means you have a right to control the policy, the keyword is policy, of a body corporate without having a controlling interest. So you have a right to control, the power to control a policy, but you don't have a controlling interest in it. So this, for example, and I'm giving an illustration. Let's assume you are an investor in a company, and you have maybe a specific education background like IT. Even if you have no controlling interest, whatever you will say, whatever advice you will issue, you will realize it will be followed in nearly all the areas. So what I'm trying to say is that when an investor has a specific expertise in a company, then you realize its advice or his or her advice will be followed in nearly all areas. I hope I'm clear up to that point. These are some of the terms you might find in the exam, so that you cannot be confused about it. Now, another maybe terminology which I may have forgotten. You might have another term called a takeover scheme. So whenever there's a takeover scheme, by this I mean is that basically you are making offers for acquisition of one for all the voting shares of the offeree. So you are making an offer to buy all the voting shares. That's a scheme. Either to buy or for all the voting shares of the offeree. Number two, such shares which result in an offeror acquiring effective control in an offeree. So if you make a scheme or make an offer to acquire shares that may, have some effect in the control of an offeree, then that we can also call, it's also a subset of what we call a takeover scheme. And then the third subset is what we call, under takeover scheme, is any shareholding of 25% or more of any shareholding of 25% or more in a subsidiary of a listed company that has contributed 50%, a subsidiary of a listed company that has contributed 50% or more to the average turnover in the last 3 years preceding the acquisition. So whenever you make, another subset is where you make an offer for acquiring any shareholding of 25% or more of a subsidiary of a listed company that has contributed. So the keyword is a subsidiary company that has contributed 50% or more of the average turnover for the last 3 years preceding acquisition. So those are some of the terminologies that I thought it would be fair that you might know. Then we also have the issue of friendly and hostile takeover. These are just a bit direct, mostly friendly takeovers deal with much of, you consent to it. You have no issue of, that particular company acquiring you. But there are certain ways, there's another way you can, or when you were confronted with the issue of hostile takeover, sometimes you might be asked, how do you save a company who does not wish to be acquired? So you realize that most target companies, target is the one that is being acquired, that are normally opposed to these hostile takeovers, may seek another company so that it may merge with it. So that particular company, the third party, the outsider, who maybe the target feels much safer merging with it or being acquired by it, is what we call a white knight. So a white knight is that particular third company that has come to the rescue of the target company. So those are some of the terminologies that I thought it was wise patie, as opposed to the normal three, the merger, acquisition, and takeover. Thought it could be wise, maybe a little bit of some of these terminologies. But sometimes it may come in exam na mwanze kushtuka. de facto ni nini, de jure ni nini. So those are some of the things I thought it would be wise so that you may be able to know. So up to that point, I hope we are clear. Before I can quickly, because time, I can go to the preliminaries so that maybe when Pareno comes, we will be able to talk about the procedural part of it. Now, whenever you're entering into any merger and acquisition, there are certain preliminaries that one ought to check. So, and I wanted to deal with, because Nani was supposed to talk about confidentiality and term sheets, which of course he had already mentioned it in the course of the discussion, but I'll just remind him. I did not go over it, but I'll just request him to go through it. If I could just remember on top of my head, the issue of legal due diligence and disclosure and disclosure letter. And yeah, those are the two things I wanted to go through so that I can release you to go and do the professional ethics paper. So these are two preliminaries, some of the, as opposed to the term sheets and issues of exclusivity and confidentiality. There are certain things that I thought would be wise because it came in our paper and I think it came in the receipt paper. What we call a legal due diligence and disclosure letter. So when you talk about legal due diligence, what is this legal due diligence? Basically, this is a review, or you are doing a review so that you are able to obtain sufficient information about the target's business, so that whoever is buying is able to decide whether the proposed acquisition represents a sound commercial investment. So if you are confronted with an exam, why do we conduct due diligence? Just say that the reason as to why we are doing due diligence is to obtain sufficient information about the target's business so that we can, the buyer, whoever is buying, is able to decide whether the proposed acquisition, whatever they are doing, represent a sound commercial investment. So when you talk about legal due diligence, basically this is an audit of the target's affairs. When I talk about the target affairs, the subsets are, the legal issues, the business aspect, and the financial aspect. So those are what we are supposed to do. Sometimes you may be asked, what are you supposed to what aspects in mergers and acquisition? When you look at our question B, I don't know C, what are we supposed to check? The checklist. So one of the things you have to check, there are a lot of things. You can check the capacity and corporate structure, its structure itself, the corporate agreements, whatever they have entered into, their commercial agreements. You also look at the business assets, computer systems, and data protection. These are some of the things you as the buyer supposed to do. Remember, due diligence. One thing you also need to know, it is now the duty of the buyer. It is the duty of the buyer to conduct due diligence. Otherwise, if you do not conduct due diligence, then now the burden will now be on you. So if you are confronted with this, you have to answer some of the questions. What is its purpose? Whose duty? What are the checklists that you are supposed to check? So you check at the capacity, the commercial agreements, the business assets, environment, health and safety, tax compliance, bribery, corruption. We also have the issue of litigation, the IP rights, whether that company, inapatiana pension, issues to do with competition. So those are some of the things that one can check when they are doing due diligence. That's all about legal due diligence. Now, as opposed to disclosure and disclosure letter, the issue of warranties and disclosure, these are some of the things that are normally considered together. And therefore, if a warranted fact turns out to be untrue, Remember, it is now the seller. The target is the target company that anafaa to disclose the information about it. And if the warranted fact turns out to be untrue, then the buyer has a claim for breach of contract, unless those particular set of facts were disclosed. So it's the duty of the seller to disclose facts. So the disclosure letter normally usually takes the form of a letter from the seller to the buyer. So the seller does a letter from with the issues to do with disclosure. Normally comes from the seller to the buyer. Then you are also advised you to go and read on the issue of what is the difference between the general disclosure and specific disclosure. Then what must be annexed to that particular disclosure letter is what we call the disclosure bundle. So it's basically a copies of documentation of what is being disclosed. So those are some of the things that I wanted to, let it out. Then maybe probably the next class, maybe I'll expound more on certain issues. So Lavins, that was what, in a snapshot, that was what I wanted to present in 10, 15 minutes so that I can let you do the ethics paper. So that is the introduction part. It's quite simple. Issues to do with term sheets, exclusivity, confidentiality. Kindly allow me, maybe the following class, I go over through these preliminaries again so that you grasp them before we, tackle the procedural part, which I think is also very important. But all in all, this first part of mergers and acquisition as snapshot, I feel it's very, 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 very important. Most of it ndio inakujanga exams. So you can just read. I'll avail the notes on Monday. They are good notes. I used to study. Somebody from Typical used to teach us commercial transaction. I'll and I don't feel the need of having them with me. I can disburse them to you for your studies. Otherwise, I hope people have understood the introductory part. Maybe the next class will expound more. Otherwise, Lavin's back to you.
Thank you, Noah. That was quite some intensive and extensive recap for M&A, and looking forward to have you availing those materials to the rest of the students for their consumption. So without further ado, I think I will just go back to the agenda of the day, and anyone with access, I saw the question, and anyone perhaps with access to that particular question paper, you can start by reading number 1. Then I'll pick it up from there. Thank you, Noah. Does anyone to read the first question for the P&D paper?
Let me read.
Please do.
Question 1. Myla undertook her legal internship at the firm of Kestel Associates Advocates. During this period, she was mandated to provide legal assistance in the firm's representation of Nestle Hospital on all medical negligence cases that were instituted against it. As part of her duties, she undertook research, prepared opinions and defense pleadings, and relied on confidential documents and information obtained from Nestle Hospital. Myla has since been admitted to the bar in Kenya and now works for Lombard Attorneys at Law. Myla executed, together with the lead partner at Lombard Attorneys at Law, signed an agreement regarding conflict of interest, which agreement was arrived after negotiations with Kestel Associates Advocates. The agreement provides that neither they nor any advocate at the firm of Lombard Attorneys at Law would engage or undertake any brief relating to medical negligence against Nestle Hospital. Myla left the employment of Lombard Attorneys at Law 2 years after executing the aforesaid agreement. Balili approached Lombard Attorneys at Law to represent them in a case relating to medical negligence. They filed the requisite pleadings to recover damages against the hospital on claims for medical negligence. A. In light of the agreement between Myla and Lombard's attorneys at law, Nestle Hospital has instructed Kestel Associates advocates to file an application in court for disqualification of Lombard attorneys. What arguments will they raise in the application before the court? Reference to relevant legal statutes and regulations must be made in justifying your answer. B. You are the legal researcher to the judge who shall hear the application. The judge has directed you to prepare and research on the issues raised. How and why should the judge rule on the application as there is no reply from the respondent?
Thank you. Can you hear me?
Yeah, you're clear.
Great. So before we actually move into the substance or the particulars of this particular question, there's always one rule about professional ethics. And this is one paper where you can easily fail and you can easily pass. So in as much as you are trying to focus on the 4 C's at the LWD, kindly, this is equally as important as well. And the role in professional ethics, I think I will start by quoting, that's what Maloa does. I don't know if he also did the same with the class that he teaches. And I do understand that your classes have, or they ended yesterday. And so you are actually left to swim through the waters of the CLE. And he always said that I'll quote Charles Dickens. Charles Dickens was a British writer and a novelist. Say that if there were no bad people, then there wouldn't be good lawyers. You see, that is the rule of professional ethics. And whenever you're answering any question, you have to immerse yourself in that two-faceted, approach. You have bad people and you have good lawyers. So where do you draw the line? So Charles Dickens was actually a social critic, and he was quite famous for a lot of works, and some of these works being the Oliver Twist. I don't know if you have come across it, but he more or less, he is the center. He is one of those scholars and writers who are at the center of professional ethics. And any question or any topic on the professional ethics, in one way or another, has to more or less borrow some, aspects of Charles Dickens' writings. So if Charles says that if there are no bad people, there actually wouldn't be good lawyers. How you would agree or disagree with that particular statement, that's up to you, and that may be subject to debate and scholarly narratives. But for this particular question, there's a reason why that part A of that question has 16 marks. So I know what you thought about it. Could be conflict of interest, and you leave it there. You have the Cabranc rule. You have the duties of an advocate to another advocate, to the public. So yeah, so 16 marks are for you to more or less scope all these marks. You have to understand what is the baseline of this particular question. So by this, I mean, what are the key things that you would easily pick out and distinguish them from the rest? Because not everything there will guide you to your particular answer. So looking at this particular question, it's 16 marks. So what are you going to perhaps work on as your topical sentence? I know your LWD lecturer has taught you about topical sentences, structure and coherence of those particular topics, and how to formulate substance given a particular sentence. So with this, we have so many topical sentences here, but we have to try and pick out what's really important. Right. So like I said, and I will still repeat, and my colleagues mention the same, that each and every word on any CLE paper has a meaning. So when you read here, Maela undertook her legal internship. So you have legal internship there. Don't just think that CLE didn't, put it there for the sake of decoration or for the sake of cosmetic purposes. No, they didn't do that. There's a reason why there's a legal internship in this particular question, because they want to understand, do you know what it means to qualify as an advocate? And do you understand, the legal effect of documents that have been either prepared or executed by persons who don't qualify, to be advocates? Do you understand the two landmark cases, the Wilson Dolo Aya, you have the Anaj warehousing? Do you understand the implications of those particular cases? So each and every sentence, each and every word, each and every alphabet has a meaning. So back to you, what are the critical things? I've given you an overview. I have opened, your scope to try and sieve out, what isn't important in this question. So those 16 marks are in the facts we've been given here. And the question, which says, reference to the relevant legal statutes and regulations must be made in justifying your answer. Very important. Okay, it's fine. In trying to answer the first question, that in light of the argument between Maela and Lambert's attorney at law, Nassau Hospital has, instructed Castle associate advocates to file an application in court for disqualification of Lambert attorneys. So what arguments would you raise now in the application before the court? Right, back to you. What do you think could be key determinants of us answering this particular question? I've given you the scope of how we will get our answers. So just back to the facts of those cases, there are a number of things, because the key word here, okay, is a disqualification. So whenever you're picking out, those critical issues of the facts of this particular question, don't more or less swerve from the keyword, which is disqualification. So Lambert attorneys need to be disqualified, because of whatever. I don't want to give you the answers, but I'd like you to tell me, what key arguments would you raise in the application before the court? So anyone? And the answers are on those facts of the case. So don't perhaps give me anything that isn't part of that particular question, because the answers are just there. So I have given you a scope of how you can answer this particular question, and always focus on those marks given. 16 marks, those are too many marks. Too many marks. Okay, so we have to exhaust those particular marks. And I understand your project marks are out. I don't know how, what kind of balancing you do to ensure that you at least get beyond, the bare minimum, which is a 50-mark pass rate at ceiling. But whatever the case, just assume you have 0 on both project and the oral exams, and focus on scooping the maximum amount of marks you could get. You could extract from any CLE paper. So 16 marks are here for grabs. Okay, and the answers are on the facts of the case, from the first sentence to the last one. I can see there's a hand that's been raised. I don't know who that is. I can't really come to see the name. Right, so back to you. What kind of arguments will we raise, to try and have this application to be as cogent as possible based on the facts that we've been given? I saw a hand up. I don't know who that is. How will we disqualify Lambert attorneys? What arguments? Because in other words, the arguments are just the facts. What facts will be raised on that particular application? And if you can't answer part A, you can't answer part B. That's a trap CLE always sets. So if part A is beyond you, then part B will be equally, beyond your capabilities, but you can always try and balance. So what arguments will you raise? Anyone? Yes, you guess the same thing.
Okay, part of my argument will be based on the fact that advocates are obligated to avoid conflict of interest, and this applies not just to them, but also to the people who work under them. Yeah, that's where I would start from.
Great. So you see, that's more or less I think Ayera is quite synonymous, with telling students that whenever you're answering a particular question, always start with a point that will tell the examiner that you know exactly what you're talking about. In other words, start with the strongest of points. Fine. You have conflict of interest, that you've raised here as one of the arguments, we will present before the court in our application. So what are the statutory, or you have statutory, you have constitutional, and you also have the subsidiary legislation framework that you could now cite, because we can't just give a point without backing it either with one of the legislative framework. So Cynthia, I mean, what perhaps cases that you know of, what perhaps statutory framework, legal framework that will support your answer?
Okay, so I'd talk about SOPEC. I'm not so sure what number it is, but I know there are 12 principles. No, 12 rules under SOPEC, and one of them is about conflict of interest. That would be one. And then the Advocates Act. Yeah, and the Advocates Act. What I'm not so sure is whether I need to remember the specific provisions, because I don't.
All right. That's okay. Anyone else perhaps with another attempt, because the first point that we've gotten, on the face of it is the conflict of interest. Okay. What other arguments would you raise? What other arguments would you raise in trying to justify your answer? There is a hand up. We have Kibuchi Mark. Please proceed.
Thank you. I'd like to say, I'd say a breach of contract, because they had engaged in an agreement that stated expressly that neither they nor they being the castle, the castle associates advocates, nor the other firm Lambert attorneys at law would engage in any matter or represent in any matter that would be against now this client. Therefore, in taking a brief against them, in taking a case against them, they'll be going against that agreement.
Interesting. Great. So you have breach of contract.
Yes.
And thank you. And I am just trying to like give you that particular pointers of how you could get to the 16 marks. So you've mentioned breach of contract. So assume you have gone under certificate to try and get the interim orders, and you filed your notice of motion. The certificate is there because the matter is of urgency. So what kind of I mean, on every application you have, we're asked upon, you have the grounds upon which your application is based, and you have the prayers that perhaps you'll be seeking as maybe perhaps interim orders. So what kind of prayers? Yes, limit yourself to the breach of contract, but there are prayers that you'll be seeking, okay? So what are these prayers? Because this is a matter that is certified urgent at Milimani, assume. So what relief will you seek? Yes, breach of contract, that's okay. I have a dispute with that. So what kind of relief will you seek? Because like I said, 16 marks are too many marks to be given perhaps through 2 points or 3 points. The examiner wants to know, do you understand what it means to have all these marks? Okay, so you've mentioned breach of contract and you can't leave it there. You have to exhaust it. So Kibuchi, back to you. I'm not yet done with you, so I'd like you to tell me what kind of reliefs would you seek? Because we all before you answer, and I hope everyone here understands what Section 3.3 of the Law of Contract Act says. I wouldn't give this, the substance. That should be on your fingertips. There are some provisions of any statutes that if you don't know by now, then you have a long way to go. So if we say perhaps on the other side of conveyancing, you have Section 38 of the Land Act, you have Section 3.3, which should be read, with that particular provision of the Land Act. You see, those provisions are things that you should be knowing at the moment, and you don't have to refer to those particular statutes to understand what it means. So at the moment, let's say we use 3.3 of the Law of Contract Act to support the breach of contract. All arguments should be in writing and what have you. So in execution, in any breach, Kibochi, what kind of reliefs would you be seeking?
As for the relief now, that's where I'm not so certain, but I'd be saying specific performance so that they can act as per what they had agreed to the contract. But I'm not so certain if it would apply in this case, because it would mean then they would have to withdraw themselves from the same matter.
Right. So perhaps will you be seeking equitable damages or common law damages? What perhaps do you think is ideal kind of reliefs to be sought here?
I'd say it is an equitable remedy, because the specific performance would be an equitable remedy. That's where I'm at right now. But if someone else is willing to give me a nudge ahead, I'd be very grateful.
Interesting. Thank you for your good attempt. Anyone else? What other argument will we be raising? We have 2 arguments in place. Okay, what other arguments would you be raising? Because like I said, 16 marks, those are too many marks to just be thrown under the bus. So what other arguments will you perhaps feel is quite ideal for you to just get to have those marks? Anyone else? I can see Marina Catherine, you come and mute and proceed.
I'm just attempting. I'm thinking of confidentiality under Section 34(1) of the Evidence Act, where the Act prohibits advocates from disclosing privileged advocate-client communication. The privilege covers contents and conditions of documents within the advocate's knowledge, as well as advice rendered by the advocate to the client.
Perfect. Very critical, confidentiality. Perhaps I'd like someone to give me the constitutional provision of confidentiality. Who knows? Who knows the constitutional provision of confidentiality?
May I proceed?
Yes. Odua
Okay.
or Omar. There is a that's you?
Yes, that's me. I believe it to be Article 31, which
Uh-huh.
speaks to privacy. And so in this particular case, then that would mean the rights of the client to have their communications kept private would be ideal. Yes.
Perfect. I can see us coming closer to scooping all the 16 marks. Yeah, so you see, I mean, because this question wants you, I mean, relevant legal statutes, the Constitution, if you didn't know, the Constitution is the main statute, even though sometimes it's not read with the same language as a statute, but it is the main statute. That's why each and every underlying statute or any subsidiary legislation has to fall beneath the Constitution. So, someone's mic is on. So, we are coming closer, I mean, to getting all the 16 marks. So yeah, you have, I mean, what Christine mentioned, you have now that constitutional provision on confidentiality. Another argument, I mean, what other argument would you raise? There's a hand that's up. I saw someone like.
Sorry, Lavin, before we proceed, sorry, I'm interrupting you. I think we could also use topic 7, which would speak to confidentiality, such that then the advocate would be barred from disclosing any client's information that is confidential within the context of their fiduciary relationship. And then without authorized disclosure, then that would amount to professional misconduct. So the same again would attract proceedings before the SEC. Thank you.
Thank you.
Sorry.
Nekesa, just Omar, just a moment before I give you that particular space to say exactly what you wanted to mention. So you've mentioned professional misconduct, you know. So when you gave an examiner, at least you tell them you know what the ACC is all about. There's an argument I think I saw in your groups, if the ADT is the same as ADC. You have the Advocates Disciplinary Tribunal, and then there's the Advocates Complaints Commission, and then you have someone who's asking if it's the same as what is that? Is it a committee or something?
The
yes.
tribunal.
Sorry?
The committee.
Sorry?
Guys were asking whether it's the disciplinary committee or the disciplinary tribunal.
Well, you see, those two are actually used interchangeably. I saw you guys were told by I think one of the guest lecturers that it's the committee or something, but they're used interchangeably. So what you have to understand is which one deals with professional misconduct and which one deals with you see, there are different types of complaints, being brought before these more or less, I don't call them ad hoc because they are statutorily based. So you have some may be referred to the other chamber if they can't be handled. So yeah, it's I don't know, some sooner, maybe perhaps next Saturday, just perhaps the first 10 minutes, I will just take you through both the ADT and the ACC and how easy it is not for you to confuse them, because it's so easy to confuse them. Okay, yeah, so, and the forms, how do you file a complaint before either? Okay, yeah, so I'll do that hopefully next weekend, inshallah. So you've mentioned here professional misconduct. Again, that's a plus, to you getting the 16 marks. And you mentioned the ACC. Yeah, what other argument do you think could be raised? Omar, I think you had your hands up. So what did you want to mention specifically?
Oh, the previous speaker preempted my point on confidentiality, so it's okay. Thank you.
Awesome. Okay, folks, what other arguments would you raise? You can just go back to the question and get from the facts, and just because the answers are just based on those particular facts. Yes, Minor.
Okay, I was requesting maybe you can explain to us on
Yes.
the issue of Myla having been an advocate at the Castle LLP. Is it associate advocate, then moving to Lambert, then leaving the employment? What would you say about subsequent representation of the hospital and the possibility of Myla being called as a witness to the case?
All right. Okay, before I respond, I just like us first of all to gather all the arguments, and I will streamline that if that's okay. Yeah. So anyone else perhaps with the arguments? Because one thing that I don't know if someone's hands is up. Catherine, you still want to say something, or whose hands is up?
Sorry, that's an old hand.
Oh, all right. Okay. Well, just back to your question, Maina. You see, one of the exceptions, to perhaps the Cab-Rank rule is that simultaneous representation. Okay, you have an advocate, who cannot represent two clients, who are actually adversaries in a case. Okay, but you have some matters, whereby an advocate may be acting for both parties involved. For example, you have a case of conveyancing. So the parties, in such a case, should have been informed maybe that the advocate may not be able to give all the information relevant to the matter, and they should have given their consent. And I think the case of King William Mills and another was Couplet in Stratton, you could see that principle was emphasized. And then the other issue is about should I say successive representation. So there's a difference between successive representation and simultaneous. So you have simultaneous representation and you have successive representation. So how do the two differ? So when you look at successive representation, it occurs in instances where you have an advocate representing a client, which may adversely affect a former client in terms of confidentiality, which was mentioned. Okay, so the advocate-client confidentiality is infinite and does not end with a court case. And I will refer you to the Court of Appeal case in England. It was the case of a firm of solicitors. So this was a 1992 case. So the Court of Appeal in this particular matter more or less observed that there was no general rule, that a firm of solicitors who had acted for a former client could never thereafter act for another client against the former client. But it held that a firm of, solicitors will not be permitted to act for existing clients against a former client if a reasonable man with knowledge of the facts would reasonably anticipate that there was a danger of information that was gained when acting for the former client, being used against him, or there was some degree of likelihood of mischief in confidential information, which is actually imparted by the former client being used for the benefit of the former client. So I think this case will help answer our question at hand. So that case is the case of a firm of solicitors. A firm of solicitors. It was a Court of Appeal case in England, 1992, Volume 1, All England Reports, page 353. So I think this is what we'll use to answer your question minor, and also for the question itself. So successive representation. And the other case that you can actually look at your convenience, you have the case of Simba Hills Farm Limited versus Sultan Hasham Lalji and 5 others. I know this is a common case, and some of you might have come across it. I will just repeat. It's called Simba Hills Farm Limited versus Sultan Hasham Lalji. Lalji is Lalji. So you have Sultan Hasham Lalji and 5 others. So this is a 2006 EKLR. So you can just Google it. I think you'll get what we are trying to say. And then the other issue about Cabranc rule or conflict of interest. And these are points that will give you 16 marks. So far, I think we have like 10 marks already. So the other point that you could raise, you have the point of expected witness. I think one of you mentioned, that issue about expected witness. And the statutory backing, because the examiner needs that particular statutory backing. So I will mention Rule 8 of the Advocates Practice Rules, okay? So here, it provides that an advocate should not appear in a matter before a court or tribunal in which matter he may be called as a witness and be required to give evidence, whether verbally or by declaration or by affidavit. I hope by now you understand, as a person who will be doing the bar exam soon, that there's a difference between a statutory declaration and there's a difference between an affidavit. And if you're asked to draft a statutory declaration, do not at any given time draft an affidavit. Okay, I hope that's clear. So in this aspect of expected witness, you can again mention the case of Uhuru Highway Development and others, versus CBK and 2 others. That's a case that civil litigation is quite, more emphatic on. And I think, you learn more about this particular case in civil litigation. So just a brief of this particular case, you have the plaintiff. The plaintiff here applied for a notice of motion that the firm of Oraro and Company Advocates, which I know most of you have sent the application for pupillage there, and in particular, Mr. George Oraro, who is the MP there, the leading partner in the firm, be restrained from acting, for the first and second defendants in the suit. The contention being that the said advocate, had acted for both parties in the preparation of a charge that is a substantial matter in the suit, and that by acting for the first and second defendants, he will be acting contrary to the law. So you have the said advocate, contended that the plaintiffs were not his clients, and he could not therefore be held to have been in breach of a duty as a solicitor to his client, and argued further that the fees paid to him were by way of enforcement of a provision made in the charge and not because the plaintiffs were his client. So you have the trial judge who, who agreed with the advocate and dismissed the application. So it was held on appeal that the question whether the plaintiffs were counsel's clients could be discerned, from a careful consideration, okay, of the correspondence on record, and in particular the fee note and notice of taxation served by him, and the conclusion will be that the relationship was that of an advocate and client. So it was further held by the trial judge that the counsel, being the author of the charge, may know much more behind the charge than was apparent, and was bound to use such knowledge against the plaintiffs, who are actually his former clients. So the court now further held that the role of a counsel or an advocate in bringing about the first and second plaintiffs to more or less execute the charge may, in the premises, lead him into consciously or unconsciously or even inadvertently using the confidential information acquired during the charge, and this will lead to prejudice. So you have this case, which will actually be beneficial to the question that we are trying to answer. So we have like 12 marks out of a possible 16 marks. Okay. Okay. And then there's another issue, I think, which will now give us the rest of the 4 marks, okay, to get the 16 marks. You have the instances whereby, the instances of where conflict of interest may actually arise in a relation, to an office or even appointment that an advocate holds, okay? Perhaps I would say you have an advocate who is maybe a company director. This is just for your knowledge. You have an advocate where the advocate and the firm has given him instructions to act for it on some given matter. Discuss. 10 marks. That's it. So an advocate in whatever situation or position as a company director should not accept instructions to act for the company. That's the rule of the thumb. Okay. And then you have another instance, because silly, as cheeky and mischievous as they could be, they would say maybe perhaps this time, oh, last tested in this way. You have judges come advocates, and commissioners of various tribunals, took up some matter in which they are maybe likely to adjudicate, discuss the ethical and fundamental provisions of this particular case. Very simple. So you start panicking, not because you don't know, but because you think it's unheard of, it's uncommon, it's unusual. So the rule of the thumb is judges cum advocates and commissioners of various tribunals should decline cases in which they are likely to adjudicate. And then you have an instance whereby an advocate should not act in respect of any such claim, for any client introduced to him by such a person or even an organization whose business or any part of whose business is to make, support, or even prosecute. Okay, so the prosecution that we are referring about here is one of claims as a result of death or even personal injury, including the claims under the Workmen's Compensation Act, CAP 236. You have, in such circumstances, that such person or even organization, that solicits or even receives any payment, gift, or benefit in respect of such claims. So you can look at this at I think Rule 5.1 of the Advocates Practice Rules. Okay. Then you have another instance, again, because you never know what CLE test. You have another instance where you have an advocate, an advocate may not actually act for a client in a matter in which he knows or has reason to believe that another advocate is already acting for that particular client, unless 3 things happen. So there's just an exception to that. 1, the other advocate, has more or less given his consent. 2, the other advocate has refused to act further. And lastly, the client has withdrawn instructions from that other advocate upon proper notice to him. And this actually provided, under Rule 6 of the Advocates Practice Rules. This isn't something that I'm just saying out of the blues. Okay. The other instance on conflict of interest is the advocate, may that will amount to conflict of interest of the case. So in such a situation whereby, the taking of the case will interfere with some office that the advocate holds or in his duties as an advocate. For example, the advocate may be a which has jurisdiction to hear the case. One of your lecturers who is an advocate, I wouldn't mention his name for personal reasons. this information you can discern, because the power of discernment for you to understand exactly what will it take me to get all the 16 marks. And that's it. So do not panic, compose yourself, summon your ancestors, summon your brain power to give you exactly the remembrance you need, because like I said, it's easy to fail ethics, not because you don't know, but because you feel it's not important. Right, so I think that part A is exhaustively answered, unless someone has concern. There's a hand that's up. Whose hand is that? Yes, Otieno.
Yes, QPLO, this opportunity, and good evening to my colleagues. So you mentioned when you're giving the some of the arguments that are necessary in this question, you mentioned the case of Uhuru Highway Development Limited versus the Central Bank of Kenya. That were two cases whereby there's a dispute between the senior counsel Jojo Raro. So just to add on what you said, it was a Court of Appeal case which held that an advocate cannot be allowed to act against a client where he could consciously, unconsciously, or even inadvertently use the confidential information acquired when he acted for such a client to his detriment. So the main thing that I catch here in this case was that it was held that the test for disqualifying an advocate established in this case was that of prejudice. So the court believed that if a client would suffer prejudice, then it would have no alternative to order that such an advocate ceases to act for the opposing party. Then it also went ahead and said that the burden of proof of existence of an advocate-client relationship may lead to an advocate being in possession of confidential information, which he could use to the detriment of the client, is on the party seeking the disqualification of an advocate. So if you relate this case vis-a-vis with the facts of this question one, I think if this case really is an outstanding case, and if you have it as one of the magic tricks in your sleeve, then I think it's a plus for you. Apart from the question doesn't mention that citing case laws, relevant case laws. It only mentions the legal statutes that we've mentioned. That is, we look at the SOPEC, SOPEC 7. What else? Section 134 and 135 of the Evidence Act, and also the Constitution that we've looked at. I think we would have done this question justice and scooped all marks. So yeah, that is what I wanted to add, PLO. So thank you.
Awesome, thank you for the insightful comments. Well, Fox, I think those 16 marks. There's a document I'll send you. You can read that document. It answers that part A exhaustively with those 16 marks, and it's just about conflict of interest. And once it's a 16-page document, and once you read that document, you can wait for Siri to bring the exams as soon as tomorrow. Get done with it and go home. So it has everything to do with conflict of interest, exceptions to Cabral rule. Name them. What circumstances would a trial lawyer apply to have an opposing counsel be disqualified from, taking part in any matter? It has everything. In fact, it's just part A to those 16 marks. And I think with what we've said, you are good to go. I'll send the document to those groups anytime from now. So part B, please someone to read. Oh, Nyongesa, just read it to once more, part B.
Yeah, I could read it. Okay. Blupo, a state council, is instructed by the Director of Public Prosecution to prosecute a robbery with violence case against Mako in the High Court of Kenya at Nairobi. The investigations are still ongoing. The hearing of the case is scheduled to commence on 30th May 2017. On 2nd April 2017, Blupo actively engages in a discussion relating to this case on a WhatsApp group with other advocates who are from the Office of the Director of Public Prosecution. In the course of discussions, he provides details of the strategy he shall employ to have the accused persons convicted. The members in the group have urged him to ensure success at all costs. A. Discuss Blupo's ethical responsibilities in line with relevant statutory provisions. B. The Director of Public Prosecution has instructed you to prepare an opinion in response to a complaint received against Blupo's conduct on WhatsApp group. You are also required to make recommendation on any action to be taken against Blupo for his conduct.
Thank you. Well, folks, believe it or not, 2 questions from this 2018 paper was copy-pasted, was copied and rather pasted on our paper last year. Reason being, a day before we did our professional ethics paper, it leaked. Yeah, CLE exams leak, but they have a backup plan. Those guys have like, I think, 6 papers. So they know if one leaks, they just bring another one. So how it happened, it's so weird. I think the guys at Kessel who are, whose exam station was at Kessel, one student was given the professional ethics paper, which supposedly was to be done the next day. So the paper for the day was, I think, was it civil? Yeah, civil litigation, the first paper. Well, he had to call the supervisor, tell him that you've given me the wrong paper. Of course, acting surprised, because no one may see the exam and let you know the last exam. So I don't know, I mean, how people took pictures of that paper. I don't know. I think now in the evening, the paper started circulating on our class group, WhatsApp class group. That paper was very tough, I wouldn't lie to you. But it was tough because, I don't know, so once it leaked, so what CLE did, because they had less than 24 hours to come up with another paper. So they took, I think, 2 questions from this paper that we're reversing today. This question 2 that Nyongesa has just read, and then there's, I think, is it question 5 or something? Yeah, 2 questions. So pray that a hard paper leaks and CLE doesn't have an option but give you a paper that was done maybe 3 years ago. It happens, you never know. Yeah, so when that ethics paper that we were supposed to do leaked, we didn't do it. So we had to do an emergency, quote unquote, emergency paper. And that emergency paper had 2 questions from the paper we're revising today. So yeah, so revised, these past papers. Okay.
Kindly send us the leaked paper. We might be brought that one. Oh my God. Yeah.
That paper was very hard. I wouldn't lie to you. That paper would be like commercial transactions that had a 90.7% failure rate. That paper
Send us the paper.
I don't know if I can trace it because it was taken through a phone's camera. How people got to have the phone, that's a subject for another day. I don't know. I don't understand, but that's it. I'll look for it. Hopefully, if I find it, I'll send it. So that particular night, guys were just, well, we were told to, just take guys through, the paper. So knowing very well the paper wouldn't be repeated, that you revise the paper right now and the next day that's the same paper you're doing, that dream only exists in Venus or Pluto. It will never happen in CLE. So it's they brought another paper. So the people who are relying on reversing this paper and expecting to find the same paper the next day, please slap yourself so hard and stop thinking about it and read, because at the end of the day, what you have to do is to ensure that you don't panic at any given moment. I'll look for the paper and send it, but it was complex in as much as I took people through revising the same and me just giving them pointers, I was still reading, okay? And that's the advice I would give you. Even if a paper leaks, because opportunity only meets the prepared mind. If a paper leaks and you don't know anything, it won't help you, okay? So that's maybe just a bonus. If it comes, well and good. If it doesn't, well and good, you're still good. So you go do the paper, pass, and get on this other side of life. So I'll look for the paper, and if I find it, I'll send it. But question 2, this specific question, if it's not ethics, then it was, I don't know, not even trial, I think LWD, but the same exact words, nothing changed, okay? You never know. Right, so part A of the question, discuss Blue Pole's ethical responsibilities in line with the relevant statutory provisions. What do you infer for this question? Anyone? What do you infer from this question, part A of the question? There's something that should be on your fingertips. You just look at the first sentence of this case and you're like, I have the answer with me. And it's a one-word answer. What's that? Actually, 2 Latin. Yeah, 2 Latin words. Yeah, 2. I have given you the clue. What is it? Hey, people. What is it?
Can I try? Is it confidentiality?
No, don't put words into my mouth. Well, I don't want to give the answer. I mean, just tell me. I mean, just read the first sentence of this particular question, and you're like, okay, I have the answer with me.
Let me think about it again then.
All right. It's a 2-word Latin term. What is it?
Hi,
Subjudice.
subjudice.
Yeah. Basically, I mean, when you can extract answers from how a question is structured. Or to begin with, what is subjudice? What is the meaning of subjudice? Anyone? You guys, by now you are almost a finished product. Like, you have all this information. You are good. You see, so your ATP calendar is done. It's just exams, and I know the things. You can be waking up at 3 a.m. and say them loud. And one of them, I sent some list of Latin terms, that are quite vital, for you to pass the exams. Okay, so what is subjudice?
Hello, can you hear me?
Yes, I can, Nikasa.
No, it's Karin. Sorry, I'm unable to raise my hand.
Oh. Okay, I'll proceed.
Yeah. So subjudice refers to when a matter is either already in court, it's being heard, or, for example, in this case, it's under investigation, and so you're prohibited from discussing it in public.
Great. So the first paragraph, at least you have that one to begin with. This is a 5-mark question, okay? Because we have to understand the ethical responsibilities in line with with relevant statutory provisions. I don't know if my law has taught you guys about the three ethical principles. No, the three principles of ethics in accordance with the Greek mythology, you know, the Platos and the Socrates. You have the pathos, you have the ethos. What's the other one? It's pathos, ethos, and logos. Those three things. I don't know if I am speaking Latin here, but those are the key principles of professional ethics. So ethos is ethics. Pathos, logos, that's an assignment I've given you. You go at your own convenience and look at what they mean. So that's where we do derive the ethical responsibilities. Fine, we've found out that this is sub judice. Paragraph 2 says that on 2nd April 2017, Blupo actively engages in a discussion relating to this case on our WhatsApp group with other advocates who are from the office of the DPP. So in the course of discussions, just a moment to tell you, in the course of discussions, he provides details of the strategy he shall employ to have the accused person convicted. The members in the groups have urged him to ensure success at all costs. So folks, gathering all your knowledge of professional ethics, this is a question that you can easily get blindfolded and answer without panic. So we've said it's sub judice, but there's this sentence, I will repeat, this sentence that starts from in. It says, in the course of discussions, he provides details of the strategy he shall employ to have the accused person convicted. End of quote. What is that? Hey, the trial process, the trial procedure. What is that? Folks, what does Article 50 of the Constitution say? I mean, the things right now that you should be singing, eh? Okay, that's how easy it is to pass the bar. If you know the key pointers that will drive you to the next, stage of your thinking. So the sentence that I've just read, what is that? Vis-a-vis Article 50 of the Constitution. Someone's talking? Who's that? Otieno? Yes.
Sorry, I'm having trouble to mute my mic. It was on mute.
Okay.
Maybe I can try.
Yes, Mora.
Yes.
Mora, yeah. Please proceed.
So I believe that first of all, an advocate as an officer of the court should first of all remember his duty in the administration of justice. So in his service, he should avoid sharp practice. I'm looking at the last sentence. The members in the group have urged him to ensure success at all costs. So I'm thinking they really want him to go for it no matter what. So I'm guessing for that, he might want to engage in some sharp practice, which is not recommended as someone who is an officer of the court. Yes.
Okay. Yes, Kinoti.
Hello. Good evening.
Good evening.
So, I believe since he's a prosecutor, one of the aims of criminal justice is to ensure acquittal of the innocent and conviction of the guilty. So he is entitled to presumption of innocence. So, but the perception that he has created is that he's already biased against the accused person. And him being an employee of the DPP, which is in fact the state, he has already shown his bias, which is, in my view, unethical. So he has violated the constitutional rights of the accused person and also his oath as an advocate and also maybe the terms of his employment at the DPP.
Perfect. I think that's what I was avoiding to mention, because I wanted you guys to just tell me. You see Article 50, okay? Paramount at any given case, and I'll still repeat this, that right now at this stage of your life or of your career towards being an advocate of the High Court, there are provisions of the law that you should be singing and don't refer at any given moment. And Article 50 is one of those provisions. Okay. So you have, the aspect of bias, and you have the aspect of, fair hearing, okay, and the rights of the accused person. And there's a whole lot of imbalance between the prosecution and the accused person. So this particular gap, the accused person wouldn't, have the luxury to be declared, innocent, because at the moment, based on the facts of the case, he has already been convicted and should be sentenced. Okay, so you see, when you measure such things, even 5 marks, I think they're so little. It ought to be 10 marks, because that content itself is enough to warrant you all the marks. It's just about understanding the art of the question. So once you understand the art of the question, then it's all easy for you to paint on the canvas that CLE has given you and come up with a magnificent, artistic representation of your brain. So what is of key fundamental? You have subjudice, you have bias, you have the rights of an accused person. And again, because I will just answer this question, even part B included. So now what happens? You have an advocate who is biased. So my question is just a matter of yes or no. Does that amount to professional misconduct as an advocate? Yes or no? Anyone? It's an open question. I mean, anyone could answer. Does that amount to professional misconduct?
I'd say it depends. Ideally, it depends on, because psychologically we all have our biases, but it depends on how you act out on it. Because if you, let's say you hide evidence or you mischaracterize evidence or statements, then it's professional misconduct. But I'm assuming as someone working in the state office, having a biased mentality is unethical, even to, the code of conduct, I'm assuming in that particular state office, it's unethical. But
great.
I don't, if you're
right,
representing
Joshua, thank you. But one thing, please proceed. You're breaking, Joshua, before I interject.
Okay, I was just saying it depends, because we all do have our own psychological biases. It's human nature. Just depends on how you act it out. Because if you hide evidence, if you mischaracterize evidence, that becomes professional misconduct. Also, if you're working as a state officer, ideally your role is public service. So there are certain principles of integrity that you should subscribe to, and because you're representing the public. Because in this sense, I believe it's professional misconduct, because he has even acted it out that his aim is to convict, to make sure the accused party is convicted and not justice to be done. But I believe if you're working in a law firm where you have a criminal, ideally, the accused person has come to you as a defense attorney and he tells you how he committed a crime and you still defend him. I don't really think there's any bias there. I don't really see the professional misconduct. Thanks.
Well, Fox, thanks for your insights. But Fox, I'd like to warn you about something, and no school will ever teach you this, that when you're about to do any CLE exams, kindly kindly do not at any given moment, okay, formulate any assumptions. Work with the facts you've been given. Okay, so by that I mean, yeah, I mean, because I am just trying to infer from what Joshua has mentioned on the aspect of the general bias as a nature of human being. That's fine. But when you have the facts of the case, work with that particular, facts. Part B is so strategic. In fact, with A, if you can't answer part A, part B will direct you to answer that particular question. Part B says you have the DPP. He has instructed you to prepare an opinion in response to a complaint received against Blueport's conduct on WhatsApp group. That should tell you that whatever Blueport did is wrong, okay, to begin with. Following up, he says you also required to make recommendation on any action to be taken against Blueport for his conduct. And it's the reason I asked you, based on the facts of the case. Well, aside from the general bias and nature of we human beings, that aside, work with the facts given. Does that amount to professional misconduct? Because a recommendation will need to be premised on any given thing. It is premised on what you've been given and the facts that are in place. So what Bluepo did, because there's a complaint against Bluepo already, and as a state council, because state councils are just advocates of the High Court, okay? So a complaint has already been received. So what recommendations would you make? And if you are to answer that particular question that I asked, if this amounted to professional misconduct, then best believe you will extract recommendation from that particular answer. So again, I ask, doesn't Bluepo's conduct amount to professional misconduct? Yes or no? Fox? Hey, you have the facts there. Daniel?
Vince, I hope you can hear me.
Yes, I can. Please proceed.
I think that the answer to your question can only be one. Of course, also related to what you said.
Yeah.
The reason as to why they're asking us the question in B, the way you stated, is because there's a problem. Something went wrong.
Yeah.
Yes, and that's based on ethics. So we're basically talking about professional misconduct. Now, we've gone through Article 50. We've seen what it talks about. Again, if you go through Chapter 6, you'll also see that it's to the same thing. Yes, you're not supposed to be biased. You're supposed to do the right thing at the right time. Now, if you go through the facts that we have, what this guy has done, so sharing this information with others, telling them, or trying to behave like he's going to do everything possible to get this guy arrested. Of course, he has gone against those rules. He has gone against the basic rules that are supposed to guide the administration of. I believe that misconduct, professional misconduct. Thank you.
Thank you. So once we have identified we are the basis for professional misconduct. So as an advocate, what recommendation could you make? Okay. Where do we refer cases of professional misconduct? Because that's the recommendation the examiner wants. Where? It's so easy to answer these questions if you understand their dynamics, okay? And you can finish an ethics paper within an hour if you know exactly what you're doing. And spend the rest of the time to just go through your answers. Well, Daniel.
Yes, Lavin. I think where we take advocates, where we have these issues, of course, you have to, of course, record a complaint with the ACC, Advocates Complaint Commission, or of course, you can also go to the Disciplinary Committee direct. But Lavin, something that maybe I'd like to bring to your attention, and something that I I think I learned during our, when we had the conference, or rather the meeting with the people from the advocacy conference, they stated their jurisdiction, Lavins, and one thing that stood out is they stated that those who work under the DPP or the AG, or those who work under the judiciary, the judges, for example, and those who are not lawyers already do not fall under their jurisdiction. And these are some of the problems that they go through in administering, or in rather exercising their authority. So here we have someone, yes, he's an advocate. Considering that statement that they told us, of course, if you go through their presentations, you'll be able to see that. And, I was also taken aback. Will it be proper to use the Advocates Act, which talks about the Disciplinary Committee, which of course is supposed to deal with advocates who are on the role of advocates, if at all the jurisdiction of the ACC and the Disciplinary Committee does not fall, does not include those who are state officers? I don't know if, but I guess the answer to your question is, the Advocates Act, and of course they fall under the purview of the Disciplinary Committee. But please just also consider that statement. Thank you.
Well, thanks. Yeah, you're right. Advocates who work under the AG and the DPP are more or less "quote unquote" exempted, from whatever proceedings that a normal advocate who works in his private practice will be subjected to. You understand? The same way they're also exempted from the CPD points. You see these points that advocates have to amass for their PCs to be active each and every year. So because I don't know, perhaps the logic I've never understood, but what stands out, maybe that's one of the reasons that the purge or the quest to more or less demote or suspend the AG as a member of the Law Society of Kenya failed. Yeah, because there is a distinction, between advocates who work under the civil office and the ones who work under the DPP. I've never understood. Perhaps should be the aspect of privilege. I don't know, but so how to proceed with this particular matter? I guess suspension. Suspension of the respective advocates, because I think once you're suspended from the DPP as an advocate, you don't have that immunity, for lack of a better term, to be subjected through a judicious process as that before the ACC or that before the ADT. Okay, that's the only ideal situation as a recommendation that you can make. Okay, because it would be a scholarly debate if we were to engage on the nitty-gritties and the eccentrics of why would an advocate who is a state counsel or one who works under the DPP, why wouldn't they be subjected to the judicious process under the ACC and under the ADT, just like me, who is in the private practice? Okay, so just working on the facts of the case, I think that will be the first recommendation to suffice pending the hearing and determination of the scholarly arguments of why shouldn't those advocates be subjected to the same process. Okay. Well, Daniel, do you have another question before I proceed?
Yeah, then again, I was thinking, Pielo, you see those circumstances where maybe you have a case, for example, sometimes we have tax cases and, this case has not been listened to before. So then you decide to go to maybe, someone's writing or a rule in another country just to persuade the court to, go towards a given direction. I'm thinking to make it clear that, yes, these people do not fall under the jurisdiction of the DC and they do not fall under the jurisdiction of the ACC. However, advocates who fall under those jurisdictions are dealt with this way. They're admonished, suspended, they're struck off, so you can terminate this person. They're supposed to pay a fine, they pay compensation and any combination of those. So just to persuade, the DCI to make a decision, you can just, tell them that this is what happens on the other side. Even though it doesn't happen here, you can borrow from it and actually ensure that justice is served at the end of the day. I don't know if that would be okay.
Yeah, that's okay. And as you can also see the language of the question 2B, it says that you can make a recommendation on any action. So by any action, you are actually not limited to that, the scholarly coherence that I was talking about, the whys and why nots. Make any recommendation or any action to be taken. Fine. You can mention ACC there. It's up to the examiner to fill in those particular gaps, because this is not a question that is asking why wouldn't advocates, who are state councils and the ones who work under the, DPP or AG be subject to the same process as an advocate in the private practice, okay? Yeah, for now, you can make all those recommendations. Could be suspension, could be issue to, or, perhaps pay fines. And then there's the issue of quote unquote recusal. You understand what I'm trying to say. There's the issue of being struck off, the role of advocates, because state councils are in the role of advocates. So basically, those are just some of the reliefs, the ADT mostly give. Okay. So yeah, I mean, so long as it's a sane recommendation that will try and remedy the particular, action. Again, you can also recommend, change of a council, but this would be hard because you have this WhatsApp group. The members in the group have urged them to ensure success at all costs. But this only means that everyone is biased against the accused person. So perhaps what you try and do is to advise the DPP to get another advocate or state council to act on that particular matter. And that council shouldn't be any member of that particular group, okay? Because the cycle will just be the same. If an advocate in that particular group is chosen to replace a loophole, okay? Yeah, so just make any sane recommendation that is fit for the purpose at hand. Yeah, that's it.
Sorry for interjecting. Would you please allow me to ask a question?
Yes, I'll proceed, Kimani.
As regards to inappropriate use of social media, would this apply in this question? Because these are advocates, they're discussing a case that is ongoing, although they are from the same place of work. I would think, and I'm sorry, probably if you had discussed this and I'm taking you back, I would think they do not carry themselves in a manner that is worth the dignity of the profession. So in my opinion, and I could be wrong, SOPEC 10 seems to apply in this context. Sorry?
What does SOPEC 10 say?
SOPEC 10 is about the advocates' use of social media.
What does it say?
Inappropriate use of social media, particularly in a manner that undermines the standing and dignity of the legal profession, amounts to professional misconduct. And additionally, material and content drawn from social media sites are relevant and may be taken into account by the regulatory authorities in dealing with the charge of professional misconduct. So, what do you think?
I agree with you. I think there was a question that was still brought out to us. Which papers that could be ethics or trial? What are the perhaps new things in light of COVID-19? That are essential to regulatory practice of advocates. You see, that's a question that has just been thrown out of the wind, and it's up to you to think and realize that social media plays a huge role in regulating the conduct of advocates. Yes, I mean that one is applicable to this particular instance because there's that should be there's a word that I'm looking for, but it is meant to just regulate how lawyers or advocates engage on social media. my lawyers calls them Twitter lawyers. That their lawyers will make noise on the streets of Twitter, and they wouldn't open their mouth to say anything on the floor of the courts. Okay, so he finds that to be quite retrogressive, because you'd find advocates admonishing and reprimanding, judges, especially judges of the Supreme Court. I don't want to mention those advocates, you know them. So they would admonish and reprimand judges of the Supreme Court because whatever reasons they have, I don't understand, but they will be slapped with the contempt of court, summons. They wouldn't honor. It's a fist fight, between advocates and between the bar and the bench. So the social media ethics really, really matters, and I think it is one of the subtopics in ethics. So yeah, I agree, Kimani. Your point will fit. Yes.
Thank you.
Welcome, Otieno. You have anything to add?
Yes, PLO. I tend to humbly disagree with Kimani on this one because okay. So peg 10, the advocate's use of social media is not relevant into the facts of this case. But the way you've explained it, it can be applicable elsewhere in terms of the Twitters and the Facebook and the WhatsApp. But now here the question says that the second paragraph says, on 2nd April 2017, Bluepo actively engages in a discussion relating to the case in a WhatsApp group with other advocates who are from the office of the DPP. So in the course of the discussions, he provides details of the strategy he shall employ to have the accused person convicted. So if you look at what SOPEC 10 says vis-a-vis the question, paragraph 138 says inappropriate use of social media, particularly in a manner that undermines the standing and dignity of the legal profession, amounts to professional misconduct. Additionally, material and content drawn from social media sites are relevant and be taken into account by the regulatory authorities in dealing with a charge of professional misconduct. So I don't know, maybe I'm getting it wrong, or I'm the one who is on the opposite side alone. But this discussion was it was let me say loosely, an in-house discussion through the WhatsApp group media, but in some way it didn't, whatever was being discussed there was pertaining to a particular, how do I put it, particular client, and how this advocate would, he provided the details of the strategy that he would employ to the accused, to have the accused person convicted, but it didn't show in any way that the use of this WhatsApp group somehow diminished, diminished the legal profession out there. I don't know if I don't want to think outside the scope of the facts of the case, but I don't see how it is relevant, okay, basing this scenario and the applicability of SOPEC 10. Perhaps if I'm getting it wrong, then I would like someone to clarify.
Well, before I do respond, I'd like to give Wamboi Muturi. I think you raised your hand. And then back to you, Daniel. Then I'll respond.
Yes, thank you. I don't know if I can be heard. Eh?
Just a moment, Daniel. I'll let Wamboi speak first.
Yes, thank you. You can hear me. I mean, walking to the house in a noisy place, so I hope I can be heard. Eh?
Who is speaking? Daniel?
No, it's Andrew who is speaking. I'm asking whether I can be heard.
Yes, but the name appearing here is Wamboi. I don't know. Yeah, just
I don't know
proceed.
why I'm being muted, but I believe I can be heard. That's why I'm being muted. So my question is, the question now, or the advocate we are discussing in this question is an advocate acting in the office of the DPP. So my question is this: there is a colleague of mine who has commented on this, that the advocates who act in other sectors, like in the office of the DPP, the office of the Attorney General, of course, they have their own their laws that govern and provide for penalties, or provide how they are supposed to conduct themselves. So my question is, if we are supposed to subject them to SOPEC and of course the Advocates Act, so that then we can if we can be guided by the Advocates Act and the SOPEC and such, to decide whether this person acted unprofessionally.
All right. Well, thank you for your insights. Who was the other person whose hand was raised before I could respond and sum it up?
It was me, Daniel. But
yes,
I'm wondering,
yes, Daniel.
There's Wambui, I think hand was up and she hasn't spoken. Maybe I can go after her.
I don't know, perhaps that's the microphone the other person was using. I am not understanding, but whatever the case, Daniel, just
Wambui is the Andrew that was speaking. We come from the same person. So Odura, I think, can proceed.
Okay, well, thanks for the clarification. So do I just proceed and then Caroline before I can wrap it up?
Okay. I wanted to reply to Mr. Forrester. Of course, he states that he disagrees. I think, PLO, if you can remember, I think you attended Maloa's classes. He talked about the enemy within. And I think that's when it comes to professional, professional practice. So yes, it doesn't have to be, the enemy within must not act in a way that it includes the other people out there. I mean, the baseline is this: what did this guy use to do whatever he did? Well, PL, I think we would agree that he used social media, he used WhatsApp, which of course falls under that, yes. And whether he did something wrong or not. Now, what did he do? If you look at the laws, he ought not to have, put that information out there. I mean, the rules are very clear. He ought not to have done that. So he still went ahead and did that. I mean, to me, I think that is misuse. That is something that he ought not to have done. So he has done something wrong. Through what? Through WhatsApp. I think it matters not whether it went to someone who is outside, whether, he only shared it with us. At the end of the day, whether you are sharing it with us, or you are sharing it with the public, or you are sharing it in a way that we are able to see, that the public is able to see it, you still ought not to have done it. So what you've done is wrong. I mean, there's no difference as to that. So I think the audience really doesn't matter. I mean, whether advocates share this information with other advocates, they're still going against that rule, and they ought not to have done it. So I think the other speaker was right. That would be my answer, PLO.
Thank you, Daniel. Kimani, and then I'll respond.
Yes, thank you. I think Forrester raised a very important point by saying that these advocates are from the same place of employment. My only question is this: so for example, what happens in law firms if we get a new client and we send out an email to all the advocates of that firm? Would that be professional misconduct? And my question is, it goes to Daniel as well, because it seems, I feel like Daniel is saying just because it was on WhatsApp, there's a problem. But again, if you send out information via these platforms you respect, for example, email, and it's information pertaining to a client, would that amount to professional misconduct? And finally, my opinion is, and again, I could be wrong, generally talking to other advocates of the same firm or the same organization, depending on the platform, may not be necessarily wrong. But in this question, the content of what they were talking about is the issue. And as you've mentioned before, this is a prosecutor. There are certain principles they're supposed to apply when it comes to criminal procedure and stuff. So I think the content is what makes SOPEC 10 apply in matters rendering themselves in a manner that is worth the dignity of the profession. So that's just, and then, sorry, I'm taking a bit of time. The last question was, when it comes to such organizations, like the organization probably isn't the right word, where there are many advocates, does the advocate-client relationship apply to the assigned advocate or to the organization as a whole? Yeah, that's it.
All right. Just to put this matter to sleep before we proceed to the next question, I'd like to perhaps refer you to Section 60 of the Advocates Act, because the term professional misconduct isn't more or less a widely used term in the context of the legal profession. The Advocates Act itself does not actually define the term. But if you check Section 60 of the Advocates Act, it states that,
a professional misconduct is more or less an expression. Professional misconduct to include disgraceful or even dishonorable conduct incompatible with the status of an advocate. So here, clearly, the concept of professional misconduct is wide, and the categories rather of behavior that will be considered as amounting to misconduct not closed. Okay, so broadly speaking, now professional misconduct is more or less a conduct in breach of the rules, the standards, and ethics of the profession, regardless whether you are at the ODPP or whether you are the AG. So that one is subject for, that's a scholarly debate, not meant for this particular, purpose. What you have to do is to answer the question and go away. So whatever that is against the rules, the standards, and ethics of the profession is considered professional misconduct. And there is a difference again between a professional misconduct and an unsatisfactory conduct. Again, that's an assignment I've given you. You go check the distinction or discrepancy between the two. So for now, what we have to do is to ascertain that Blupo was in breach of the rules, standards, and ethics of the profession. And this breach came about through unsatisfactory and unprofessional use of the social media ethics that govern advocates. That's one. So Forrester, that will apply still in this particular case. How you will argue that case will now be the difference, okay? But anything that contravenes the rules, the standards, and ethics of the profession as an advocate is tantamount to professional misconduct or unsatisfactory conduct on a case-to-case basis. So that's the bottom line. And these people, whether you work as a state council or not, you are an advocate first. You are on the role of advocates, and you can be struck out based on any proceedings that has been brought, against you because of your breach of the ethics, the tenets, the principles, the rules, and the ethics of our profession. Okay, so I guess that one puts the matter to bed. Anything else, perhaps, is just a scholarly debate. And I would again advise you, maybe perhaps a thesis for your master's would suffice, because it's good that you have identified the lacunas or areas of law that need to be more or less addressed. And that's one of them. So you never know. And again, I don't know if you have access to the Code of Ethics and Conduct for the legal profession as at 2016 by the LSK. Not just the SOPEC, there is the Code of Ethics and Conduct. These things are quite many. So perhaps what you are referring to should be read, with the other, policies or rules that govern the conduct of an advocate. I will share the same together with the conflict of interest material that I told you about with time. So I think with that, you would allow me to move to the next question for the sake of time. And I think that's question 3. So, Nyongesa, I don't know if you're still around. You can read question 3.
Okay, I will read the question.
You can project it.
Oh, project. Oh, no, I'm not able to project. Maybe someone else can.
Let me do so. Just a moment.
Yeah, I just have a lot of windows open.
When it's taking time to load, or just Cynthia, can you hear me?
Yeah, I think Sophie wants to help.
Or please do, because I think
Hi, Cynthia. I've tried to project. Can you see anything?
Yeah, I can see it. Just scroll down to question 3. It's currently reflecting the first question. Yeah, so just scroll to question 3. Okay, I will read question 3. Kulolo completed the LLB program in 2010 and his diploma at the School of Law in December of 2012. He was admitted to the bar in September 2013 and applied for his practicing certificate on 15th April 2014. On 1st March 2014, he was approached by Mwangangi to assist him in preparation of an agreement of sale and transfer relating to the sale of land. He obliged. Upon demanding for fees, his client declined to settle the fees agreed upon. Kulolo filed a bill of costs for taxation. A. Discuss the validity of the documents prepared by Kulolo, noting to cite the relevant statutes where applicable. B. Discuss the ethical issues that Kulolo needs to consider.
quite a fair question. Anyone? That's an easy question. Validity of the documents. What case comes to mind? Quickly. What word?
Yeah. So what case comes to mind? National Bank of Kenya Limited versus Anajia Housing Limited, 2014 Supreme Court. Yeah. So basically, the main issue in that case for determination was whether a document or instrument of conveyance is null and void for all purposes on ground that it was prepared or attested to by someone who is an advocate but doesn't have a written practice certificate. So I think in relation to this case, it's important that we take into consideration the dates that we have. So Kulolo is admitted in 2013 September. On 15th he applies for the practice certificate, but on March 2014. So March is before 15th April. So of course, when he was preparing this document, he didn't have the practicing certificate. But when he was preparing this document, he was already admitted. He was already under the role of advocates. So that should also be taken into consideration, because if you are not in the role of advocate at all, then of course we have a problem there. The rule would be different. So my answer is, since he's already in the role of advocates, of course the documents are are valid and they're not null and void. And of course this can also be addressed by, if you look at section 34B, and that was an amendment, I think, after this case, after the Anajia housing case, they made that amendment. So yes, the documents are valid and you can buttress it using that. I hope that's okay. PLO.
That's perfect. Could you now contradistinguish it with the case of Wilson Doloaya? What are the tenets of that case?
Well, of course, Wilson Doloaya, made a different, decision in relation to this case. Their decision was different from this one. But I think something that we have to take into account is that that case was decided before, of course, the Anaji warehousing case. And of course, in that case, PLO, they stated that actually this document would be considered as null and void. And if you look at the case of Anaji warehousing, this was discussed. If you look at paragraph 35 of that case, National Bank of Kenya versus Anaji warehousing, they talked about, whatever happened in National Bank of Kenya versus Wilson Doloaya. Of course, it entailed a mortgage and not a charge. We like talking about a charge so much, it was a mortgage. And of course, looking at the parties' intentions and everything, the appellate court judge decided that, of course, those documents were null and void. And for me, I believe that Anaji warehousing is a better decision considering the arguments that they put for us, all the rationale behind it. So Wilson Doloaya said the opposite of Anaji warehousing. I mean, that is how I would clarify it for me.
Perfect. So what do you think are the ethical issues that Claudio needs to consider? Because part A, we are done with it. Part B.
Well, if you look at the Advocates Act specific, and of course, if you look at the rules under professional, the certificate, the current certificate, and the rules, of course, you'll realize that practicing or doing something that an advocate ought to do without a practicing certificate is prima facie, professional misconduct. So I think we start from there. That was professional misconduct. So the fact that he sat down and decided to draw up these documents without that practice certificate, that was a prima facie case of professional misconduct. Maybe we can add more to that.
Right. Thank you. Anyone else perhaps with an input on the same? Sophie, your hands is up. Sophie, can you hear me? Or Cynthia?
I think my hand, I wanted to answer a previous question. I think it has been up for a long time, not on this question.
Oh,
so
okay.
Somebody else can just take it up first.
So, Cynthia?
I'll take it up from the previous speaker. In the case at the Supreme Court, which I believe is the just hold on. Yeah, the case at the Supreme Court is the National Bank of Kenya Limited versus Anaji warehousing. So in terms of ethical issues, I would also talk about the duty of care, because when you examine the case, you will see that the court held that in as much as the documents would still be valid in as much as they were drawn by an unqualified person, the court insisted that advocates have a duty of care to their clients and have to take reasonable precautions to ensure that they have a valid practicing certificate.
Ideal, I agree. So you have the duty of an advocate to the client and even to the opposing counsel. So those are some of the key things that you should address for the 5 marks. And because of that, I think we have exhausted that particular question. Unless someone has a concern. So question 4. For Sophie.
Okay, I can read question 4. A leading Nairobi business a leading Nairobi business, I think businessman, Dr. Malimingi, is owed 1.5 million Kenya shillings by his long-term customer, Mr. Pondamali. Mr. Pondamali is deliberately refusing to pay the debts. Dr. Malimingi instructs Advocate Fixit Otoyo of Otoyo and Company Advocates to recover the full amount expeditiously. Advocate Otoyo seeks and is paid a deposit of Kenya shillings 240,000 to cover strictly court filing fees, complaints, service of summons, and minor disbursements. They agree that legal fees will be payable if Mr. Pondamali defends the suit and it is fixed for full hearing. Advocate Fixit Otoyo promptly files the case. He pays Kenya shillings 70,150 for filing the plaint, Kenya shillings 5,300 for service of summons, and Kenya shillings 6,550 for all other expenses. On learning that a case has been filed against him, Mr. Pondamali promptly paid the amount claimed, and they agreed to end the matter at that stage without other claims. Dr. Malimingi is contented and promptly advises his advocate to close the file, which he does. From your knowledge of professional ethics and practice, is the conduct of Advocate Fixit Otoyo proper? B, discuss 2 possible professional disciplinary charges he is likely to face.
All right. What do you infer from the question? Anyone? Anyone? What are the legal obligations, the ethical obligations breached by Fixit? What is it?
Can I say something?
Yeah, yes, please, Mboy.
I think that once a case has been filed and summons have been taken out and they have been filed and they have been served, I think it is proper to wait until the other party responds before any other proceedings. But in this case, Mr. Pondamali has not even responded to the summons. I mean, he has not possibly entered appearance. So I think it's not like like the case has been withdrawn prematurely.
Yeah, good point to start with. Anyone else?
Yes, if I may contribute something.
Yes, Ngebo.
Yes, the deposit was of 240,000. Okay. Maybe this can go first.
Okay, from my opinion, I thought that the advocate's fee should be charged according to the ARO, the Advocate's Remuneration Order, as provided by Section 44 of the Advocates Act. And from what we've been told from the excerpt, the Mr. Fixie Totoyo is overcharging the client. Thank you.
Interesting.
Yes, maybe.
Yes,
maybe.
Yes,
maybe to add on
proceed.
that. Yeah, I think the previous speaker read my mind, because for me, I had an issue with the amount. The deposit was of 240, and it was indicated that the amount is for filing fee, and the advocate has spent around 80,000 to file. So it means there was overcharging. So for me, I feel as an advocate, you owe your client a duty to charge a reasonable fee, and that fee should be charged according to the remuneration order. So for me, I feel the conduct was not proper based on that argument.
I agree. Daniel?
Based on the same thing, deposit, I also believe that advocates are supposed to be paid for work done or anything that they've done, of course, in the interest of the client. In the statement, we are told he sought that money even before, they had gone to hearing and all that. So to that extent, I think that was wrong. This money is supposed to be paid later on, maybe under taxation, or maybe if they had an agreement.
Yeah, and also there's the aspect of fees based on a future promise. You see the aspect of where they agree that the legal fees will be payable if Mr. Ponda Mali defends the suit, okay, and it is fixed for full hearing. You see, there's that aspect of future promise, for an advocate to be paid their legal fees, and you can cross-check also with the is it Champati, and there's the other one. There are two things that are based on a future promise, that any amount will be paid on a future promise, either the case is won or defended successfully. I don't know. I can't recall the two words. There are two things. What are they?
Contingency.
Well, yes, but there's still other two. I don't know, Daniel. I can't recall.
Like referring to invalid agreements.
Sorry?
You're referring to the invalid agreements, right?
Yes, but there is the word for it, like almost a whole topic on that. There are two things. I can't recall. It's here, but I can't count. Around it. I've forgotten. Huh?
I think you're referring to a situation where an advocate is not supposed to wait for the outcome of the case in order to hedge the fees.
Yes,
and
that's
then
it. It is illegal. Yeah, that's what I'm saying.
The other one is where somebody else finances the case. A third party now comes in to finance the case in order to benefit from the proceeds of the case.
Exactly. So what are the terms for it? There are two terms for those two things that you've mentioned. I've forgotten. What are those two terms?
Is it maintenance?
Well, oh my goodness. I can't remember, but I had it here on my fingertips. I don't know where they've got.
Champati agreement.
Champati is one of them, but there's the other one as well.
Touting.
Yeah, could be that.
Contingency.
It's not touting.
What is it? Well, what you people should do, just do that assignment, find out what it is, and let me know. If your answer is the correct one, I'll tell you, but I have forgotten.
You can proceed. I'll tell you the answer just now. I think I can reverse. I'll get it in 5 minutes.
So, okay. So I think my question 4 is done. We are okay with it, unless someone has a concern. Because those disciplinary charges will just be premised on what Part A has, which we have exhausted. Question 5. What does question 5 say? Is that the last question? Question.
We have 5 and 6. So
okay,
2
5.
more.
5. Yeah, quickly. Question 6 isn't that hard. Question 5. Read it.
Okay. Despite the already existing corpus of legislation and subsidiary legislation that exists to regulate the various aspects of the legal profession, the Law Society of Kenya has realized that there are still new and emerging issues that have arisen and for which there currently exist no guidelines. Select 5 contemporary issues which, in your view, are not regulated at all or are not well regulated within the legal profession in Kenya, and discuss each issue, noting its impact to the profession.
One.
If I could.
Yeah. They're quite a number, especially in light of COVID. You can mention quite a number of things. Yes. Who's speaking? Wanambisi or who? Who's that?
Yeah, it is Wanambisi.
Yes. Please proceed.
Oh, yes. Well, actually, mine was outside the precincts of COVID, but I was trying to talk about the issue to do with advertisement, especially on social media platforms.
Mm-hmm.
Yes, it's a cropping issue that is coming up, and I think it lacks regulation in one way or another. Yeah.
Mm-hmm.
Yes.
Yeah, I agree. Advertising, and then what's the other issue?
Well,
just talk.
No. I think I've exhausted my thoughts.
Well, there's also the aspect of e-filing. I don't know if we have substantive legislation or subsidiary legislation on the same, and it needs a wide corpus of legislation to at least govern the same, because at the moment, even senior advocates still struggle with e-filing of matters, and I think this came about in light of COVID. And then there's the use of ICT with the legal profession. Perhaps you have
e-conferencing or hearings, done virtually. So the scope of that again, isn't well regulated because evidence may be lost or won based on how strong Wi-Fi connectivity is, and you see that one defeats the purpose of a fair hearing. And then there's also the aspect of how can I put it? The aspect of well, such as done online for LANs. Okay, yeah, this is a perhaps system hack because technology is always susceptible to its own challenges. And again, given that the Cyber Crimes Act was more or less rendered inanimate for lack of participation by the Senate, well, it needs to be republished again by the National Assembly to get through all the processes, because what Senate wanted is the concurrence as the Constitution requires. So any other thing that perhaps needs to be regulated more? Yes, Forrester?
Yeah, I just wanted to mention that since the previous speaker has mentioned about advertising, I do agree that yes, there's no any rules or legislation governing the use of social media advertisements. However, there is the Advocates Marketing and Advertising Rules of 2014. So you see, if you see these rules, it doesn't talk about social media advertising, but as a matter of contemporary issue, I do agree with what he has said about the regulating of advocates on social media.
All right. So any other inputs? But I guess we are good for question 5. So the last question, Sophie, quickly.
The Constitution of Kenya 2010, Article 52G provides every accused person has the right to a fair trial, which include the rights, G, to choose and be represented by an advocate and to be informed of this right promptly. A, would you accept to represent an accused person in a case in which you consider the defense to be very weak and therefore a slim chance of success? B, would you reasonably accept to represent a plaintiff in a civil claim you consider very weak? C, why would you render pro bono legal services?
Well, I think this question was also the one that came during our trial paper. The same question, the way it is. Yeah, trial. If not trial, it's ethics. One of those papers. The same question as it is. So clearly, just they're too lazy, to set exams. They'll just be picking from here. So yeah, so you have to know that and go through all these papers before you sit for your bar exams. All right, but A, will you accept to represent an accused person in a case in which you consider the defense to be very weak and therefore slim chance of success? Anyone? By the way, you start first with yes or no, and why? Okay. Anyone? In other words, these are just the exceptions of Cabranc rule. Okay. Does this fall under that exception of Cabranc rule? There's Moita Karen.
So I would accept to represent an accused for the scenario that's been given, and I would rely on the rights to fair hearing provided in Article 50 of the Constitution, which states that every accused has a right to be presumed innocent until proven guilty or until the contrary is proven. And I think by declining to accept a brief just because, in your opinion, you believe that they have a slim chance can be tantamount to usurping the role of the judge, because the judge is the only one who can, or the court is the only one that can determine whether or not the case has a chance of success.
Perfect. Yeah. So how you answer this question will determine if the examiner will proceed and listen to your arguments. Okay. Yeah, so that essence of the court having the power to determine whether the evidence is weak or not isn't meant for the advocate. Your work is to represent, and your work is not to adjudicate. There's a difference between, there's a whole difference between the two. All right. What other reason, perhaps, would you give? Anyone else?
Yellow, my hand.
Yes, proceed. You know, sometimes I'm not even seeing these hands. Yeah, proceed.
Okay, so we also have the cab rank rule, and I believe
Yes.
this falls under the cab rank rule. It doesn't fall under the, the exceptions that you stated. It falls under the cab rank rule. Then again, I think we also have Article 48 of the Constitution on access to justice. Then again, we also have equality. It doesn't matter that his case is weak, and he'll lose. He still has the right to be treated equally.
Yes, perhaps for the purposes of clarity, what I mentioned is you have the cab rank rule and you have the exceptions of the same, and whether that particular question will fall either as an exception or not. So your point is okay, and I think to add what Karen said, that's a plus. Nyongesa?
You can also talk about duty to self. My understanding of when you're taking your oath of admission is, I don't know what the exact words are, but I believe it's something related to defending the rule of law and justice. So by taking up the case, then you are going by your duty to self.
Yeah, that's
makes sense.
great. That's the duty of an advocate to the general public. You have to defend the rule of law, and the rule of law comes in different facets, and one begins with even your own client. So, in as much as you have the duty to a client, and the duty to the general public, and the duty to the profession itself, so all those duties, I think, they're centered in one way or another, they intertwine. So they're mutually dependent on each other. Part B, would you reasonably accept to represent a plaintiff in a civil claim you consider very weak? Same arguments? Anyone? Hey, folks. Yes, Daniel.
I'm thinking that there's a twist to this, because
Yes.
advocates are not supposed to waste court's time. Now, if you look under the rules, and of course, if you consider the case of DT Dobby versus Mushina, you'll realize that where we have a case that is so weak that even an amendment to the pleading would not help it to still sustain or to be listened to by the court, then that case will be dragged out. So if this case is so weak, then why take it to court? It will be struck at the end of the day, and you're just wasting judicial time.
Well, as Professor P. Lumumba puts it, they say of small things the court knows no cure. It's about you as an advocate. You owe a duty to the court, and one of those duties is the time consciousness. So if a matter is supposed to more or less waste the court's time, as you've put it, and it's meant to just derail or entertain the plaintiff, when in real sense the case has no spine, then it has to be sanctioned. Okay. Yes, Kimaru.
Just to ask something, or just to point out something, I believe no matter how strong or weak the case is, what is prime and what is important is the right of fair hearing. Therefore, even if, in your opinion, the case is weak, you can't just skip the process of hearing. The person has the right to be heard in court. They have a right to their day in court. If it is so weak, the prosecution or the other side will prove their case, and it will be summarily or held. It will be closed off quickly. Don't think it amounts to wasting the court's time, because even the accused, they deserve a right to their day in court. That's why we have Article 50.
Well, I agree with what you're saying, but disagree on one thing. You see, this is a civil claim. I think that's the key word. So the things there's something Nani mentioned, Daniel. The things when the court looks at your pleading and it sees that even no amendment will cure the defect, then you know you have a poor case. Okay. Well, it may perhaps suffice to say that it's not you to consider, the claim very weak. Well, the court may find that on your behalf, but that's why you are more or less mandated to advise accordingly, because the client will only rely on your instructions. And the instances where the instructions of a client may be overridden, because the bottom line is we have a duty to the client. That's okay, that's fine, to take instructions, and what have you. But those instances whereby an advocate will advise and act in a manner that is meant to override and the instructions given by a client, and that will only mean that it is in the best interest of both parties. But bottom line is, and don't misquote me, bottom line is advocates are meant to take instructions from client. That's okay. But instructions themselves should not be misleading, okay? Or they are meant to perhaps waste the court time at the expense of entertaining the client. Yes, David, before I come to you, one boy.
Adding to the foregoing,
Yes.
I would think then would it be in order for you to, on question A, B, bring in the issue of advising your client on plea bargaining for criminal cases and out of court settlement for civil cases?
That's fine, but you see, when it comes to plea bargaining, it has to involve a lot of parties. But that's a whole new procedure, and we may not really exhaust with these few minutes left. It's a whole new procedure. It involves, the DPP, the victims. You take the report to the judge. Actually, the judge or the magistrate is never involved in plea bargaining. What they have to, their only involvement is what has been agreed. And you understand, so plea bargaining could again be withdrawn. So it's a lot of complexities and what have you, but yeah, that's a good point regardless. Yeah, so I think advice comes, in handy. You can accept the case, but still advise on the, perhaps weight or predict on our success given the, cases at hand. Well, yes, one boy.
Yes, I'm just wondering whether saying that someone has a weak case means that this person or the plaintiff doesn't have a case. I feel like the fact that the plaintiff has a weak case, it doesn't mean that he or she doesn't have a case. And it means that it's only that the evidence is not that strong that this person has a case, because we are not told like this case is it is a case that has been that fall under the statutes of limitation, or it's a case that is vexatious or frivolous. It's only that the case is weak, and I believe this is a conclusion made depending on the evidence maybe the advocate has in his possession, but doesn't mean, to me, I feel like it doesn't mean that you cannot file this case because you consider it weak. So for me, I'll say that I'll conclude that I'll take up the case and I will file it in court and proceed as it is.
All right, thank you. Joshua?
Good evening. I believe question A and question B that they're seeking from you whether you know the disparity between our criminal proceedings and civil proceedings in regarding to both a plaintiff and an accused. Because I believe in a criminal proceeding, as you said, you have a constitutional right to be represented by counsel. And on top of that, there's that whole presumption of innocence and standard of proof being beyond reasonable doubt, in that a slim chance of success in a criminal matter is still in the pursuit of ends of justice, and that's all you need. But in a civil claim, there's no constitutional right to legal representation in a civil claim. And on top of that, if the case is very weak in that it doesn't show a cause of action, it can actually be, an abuse of the court process. So I think in answering this question, it's just to show the differences, when it comes to carte blanche in a criminal dispensation, in criminal proceedings, vis-a-vis in a civil proceedings. Thanks.
Yeah, sure, thanks. I think with all the points that have been put across, what you have to understand is to sieve and understand where the trap is. Part B is basically civil, but A is about, criminal. And, for both angles of the justice system, they have their own procedures, and one would ultimately outweigh the other. So if you're at Court Article 50, the Constitution in Part A, Part B, it basically means this can be solved, even perhaps through out-of-court settlement. You're not even supposed to go to court, because why waste all the filing fees, presentation hearing, when you can solve it out of court? Because basically the likelihood of your case succeeding or even being thrown out by the court in Part B is higher. So why not settle for an ADR and Article 159, I suppose, of a constitution that gives alternative dispute settlement. Okay, yeah. So not everything deserves to be taken to court. The court should be the last resort. So there are things you can explore the ADR mechanisms before you do that, and you'd even be surprised that it works wonders, and it's a win-win for both parties, because you understand you have a claim that is weak. And if the rule is, if the court finds that your pleadings are so weak that they can't, even with amendment, nothing can be done, then you understand that you are there for embarrassment. And as an advocate, you wouldn't like to be embarrassed by the court in such a manner. So you weigh your options and see which side of your bread is actually buttered. Okay, so lastly, Part C. Why would you render...
Sorry, before go to Part C, in Part B, would it be correct to quote Article 50? I think that would be wrong.
Yes, it is wrong. I said Part A should be for Article 50. Part B is basically civil claim.
Okay. I thought. Okay, so thanks.
Yeah, you're welcome. Part C. Why would you render pro bono legal services? This is so easy. Daniel?
Well, for me, just to back up my yes, this is what I'd say. If you look at the report by the British Royal Commission on Legal Services, apart from the fact that, we are in a profession, of course, some of the characteristics of that is that, our name are under a certain role, we are also public servant. So then to that extent, as a public servant, I'd offer my pro bono services to others just to be able to serve the public. Then again, as an advocate, we are the protectors of the Constitution, of course, including everyone else. And if you look at Article 48 of the Constitution, it provides for access to justice to ensure that each and every person can access justice, whether you are poor or rich, and offer pro bono services.
Well, like I said, this is a debate that may never end, but you have to understand the principles for both the criminal justice system and the civil justice system. And how you come to the conclusion, it will depend with your discussion. But I think the position that I've raised and what some of you have put across, it's more or less a guide, to know exactly what and how to answer such questions.
Wamboi, before we proceed to part C.
Yes, maybe to add on what the previous speaker have indicated. Yes, in answering this question, I would say yes. Sorry, I would say because, the question is why would you offer pro bono legal service? I would say because, of course, as an advocate, this is one of the duty that I owe to the society, that is to offer legal aid and legal services. Thank you.
PLO, I was answering question C.
Okay, yes. Yeah, got it. Any other person, why would you render pro bono legal services? That's basically about Article 48, access to justice, regardless of the status of someone in the society. Any other person? Yes, Ngego.
The reasons that I would offer pro bono service is that the more the public participates, the more the legitimacy, and the more it boosts the confidence of the legal system. That is, the public also believe in the legal system, and that is our role as advocates to portray. Thank you.
Very, very important. The role of advocates is to inspire confidence of the judicial service system to the public, because some members of the public, have lost faith in the courts. Okay, so if we were to do, that's why we always do pro bono legal services as a way to amass CPD points each and every year to keep our PCs active. So we're just there to inspire confidence, hope, belief, and faith to the public, so that they can be, coming to courts more often, because at least they know lawyers or advocates aren't detached from them. Okay, so we act as a bridge, between the courts and the public. Yeah, so ladies and gentlemen, it was a pleasure doing this. And like I said, I hope I will be engaged, because we are busy. I'm busy, extra busy. So at least I find time to dedicate to this particular course. So yeah, I still hope that you guys are reading and doing your best to at least have something to smile about when your results are out. And regardless of the marks that you got on your project, that shouldn't worry you. Keep on working, keep on doing what you can. Yeah, the best is yet to come. So if you don't believe in yourself, I still do, and I'll keep on telling you this. You are well equipped. What we are doing here right now is just to put the icing on the cake, and to expose the rest of the icebergs. So yeah, David, what do you have to say before I adjourn the session?
I had said I look into that word that you had talked about. The two names are champati and contingency fees.
All right, thank you. I think one of you raised that issue, but thank you for confirming. So I'll send the two documents, the LSK Code of Ethics that I talked about and the conflict of interest document to your respective groups after this. So yeah, all the best. And if you have any question, I am always a button away. I may not respond immediately, but at least I always respond. That's what matters. So yeah, all the best and have a good night and a blessed week ahead.
Thank you.
Thank you. Good night.
Thank you.
This was very good.
Much.
For brothers.